Hi, everyone. Thanks for tuning in. I hope you can hear me. If you can hear me, leave a note in the chat that says that you can hear me, okay? I'm just going to wait to make sure you can actually hear what I'm saying. This lighting is terrible in my hotel room. I look so orange. Okay, great. Thanks. Thanks for letting me know that you can hear me. So I'm Christine. I'm the litigation director with the Canadian Constitution Foundation, and we just wrapped up court for our first day in Vancouver. I am here for our appeal at the Court of Appeal of British Columbia in a legal challenge that we brought to the vaccine passport policy in British Columbia. For those of you who don't remember, I sure do. It was a pretty terrible time in my life, but the government had imposed these vaccine passports. It required you to show proof of vaccination if you wanted to not just like go into restaurants and bars and museums and stores, but you needed to actually check people's proof of vaccination to have guests in your house, your own home at Christmas. You could only have vaccinated family members come into your home at Christmas. So I actually had kind of memory hold that particular saga, the fact that you in Vancouver weren't even allowed to have family member or friends over for Christmas if they weren't vaccinated. But yeah, that is a thing that happened. So we are appealing the policy of vaccine passports. I've talked about our strategy a couple of times before. We are focused on a narrow issue because we are looking to have some success in the courts. So we have really tried to hone in on the most sympathetic stories that are possible. So we brought an appeal with 3 women who couldn't get exemptions, medical exemptions from the vaccine passport process. I've talked about them before. One was a woman who developed a serious medical adverse reaction to the first dose. She got pregnant and then she was afraid to get a second dose. Very reasonable fear to have. Her doctor shared her concern. They told her not to get vaccinated, but public health seemed to know better than she did, and then her doctors did, and they told her that they thought she should get vaccinated. Another woman was a very medically complex woman who has a disability since birth called spina bifida. She has a number of adverse drug indications. She has had 15 surgeries in her, I think, 30 years of life. And she's had so many adverse reactions to medications. She just didn't feel safe taking the COVID vaccine for a lot of different reasons. But she was denied access to public pools that she needed to use in order to manage her disability. She did about 3 hours of swim therapy every day, which sounds like a lot of swim therapy, but that was literally the only mobility she had. And then our third applicant in this case was a teenage girl who developed heart inflammation called pericarditis after the first dose of a COVID vaccine. So I know a lot of you have asked me why we didn't challenge the regime broadly. I obviously have a lot of concerns about the regime from just a general point of view, but as a strategy, what we wanted to do was to pick very sympathetic applicants and challenge the regime on the basis of medical exemptions, because we think that we can get a win there. And I do have a really exciting update for you about the case. So the big thing that happened today was we spent almost the entire day, the government was arguing that the case shouldn't be heard. They said that the case is moot, which means that there is no longer a live issue before the court. And they spent a lot of time saying this. There haven't been vaccine passports for 17 months. The women in our case, they have been able to enter public spaces for the last 17 months. Nothing has impacted their rights since these things have been no longer enforced. And by the way, their rights were never violated to begin with. Like, that's such an egregious position, but that's on the merits. So what the government was saying was that the case shouldn't be heard because it is moot. And there's some important case law on this concept of mootness. Mootness means that there's no longer a live issue, that the outside events have resolved the case. But there is a test that comes from a very important Supreme Court case called Borofsky about whether or not a case can still be heard even if it is moot. And in Borofsky, the Supreme Court said that as part of a general policy, the court can decline to hear hypothetical or abstract questions if the case is moot. And he described a two-step test for determining whether an issue is justiciable, which means it should be heard. First, the court must determine whether the requisite tangible and concrete dispute has disappeared, rendering the issue academic. And if so, the court must decide whether it should exercise its discretion to hear the case anyway. So we sort of took we took that two-part test head on. We argued, first of all, we said the case isn't moot, that the government might bring back vaccine passports in the fall as the fall respiratory, illness season increases, and that they may bring back some form of vaccine passport. And the government has not committed to never bringing back a policy like that. So it's not moot. And then we also said it's not moot because in healthcare settings, these vaccine mandates do still apply. So there is still some form of this policy, even though it's not the same, there is still some form of policy on vaccine mandates. And then we also argue, look, if the court says that it is moot, they should still exercise their discretion to hear it because this is a matter of public national importance. It's really important case law. It's a very unique case. We've never seen anything like this before. And the courts and the government need some type of guidance in the event that there is another crisis. And if there is another healthcare crisis or any type of emergency, there's a high likelihood that if a policy were brought back, it would have some aspect, even if it's not identical to the vaccine passports we saw before, it will still have some similarities. It will still probably restrict people from public spaces. It still will engage Section 7 rights to life, liberty, and security of person. It will still interfere with this, what we were calling in court today, the freedom to roam, to move around society as a free person. It will likely still engage that, and it will likely still engage Section 15 equality rights. And in our case, the equality rights were engaged because the people in our case were experiencing disabilities. So the government was arguing strenuously that the case should not be heard. They've argued this in so many other cases. There have been so many COVID-era cases where the government has evaded charter review because they said the case was moot or they relied on some procedural argument. So this hearing, it wasn't just ours. It was also brought by another organization. They were all heard together. The other organization is called the Canadian Society for the Advancement of Science and Public Policy. And there was also an individual, and that organization, the Canadian Society for the Advancement of Public Policy, they had a broader argument about the vaccine passport regime as a whole. And then there was an individual who also had brought a legal challenge that was being heard. His name was Maddock. Maddock is not a lawyer, but he's trained as a lawyer, and he represented himself. And his issue was with the food and alcohol restrictions, so the inability to go into bars and restaurants because he often has to meet clients. He's a legal researcher. He had to meet clients in coffee shops, and he wasn't allowed to go in. It interfered with his livelihood. And he personally was not vaccinated. And he made great submissions about, he was sort of part of something that was brought up was why wasn't he vaccinated? And he gave some really compelling statements about he doesn't need to give you a reason why he's not vaccinated. He has the freedom to choose whether or not to get vaccinated, and it doesn't matter why. And I did think that his arguments were compelling. So you might be wondering what happened, right? So most of the day was spent on these mootness arguments. And the really exciting news, and this is a huge deal, is that the court is exercising its discretion to hear the case. They said that the case is moot, that external issues have resolved the dispute. These vaccine passports are no longer enforced, but the public interest weighs in favor of them exercising their discretion to hear the case. So I can't express how excited I am that we have proceeded to the merits of this case, because so many of these government measures related to COVID have evaded constitutional scrutiny and charter scrutiny from the courts, because the government has relied on these arguments that, it's all over, it's all done, or they've relied on procedural arguments with the lower court. The lower court in this case said that they didn't need to hear the case because the applicants in our case should have used a administrative system that we say is actually not even available to them. So this case is not going to evade review. There is going to be review in this case, and we started that review today. So it was really exciting. We went to break. We didn't know what was going to happen, and the judges came back in and said that we will be hearing the case. They're keeping our case. They're keeping the what was the name of that organization? The Canadian Society for Advancement of Science and Public Policy. They're keeping their case. But they did boot Maddock, the individual, because they said they didn't give reasons. They're going to give the reasons for why they removed Maddock on Friday. But based on the questions, it seemed like they seemed concerned based on their questioning. And maybe there's another reason. Based on their questioning, they thought, why do we need to keep Maddock when Maddock's issues would be resolved by the other two cases? So maybe there's another reason, but that's what the line of questioning led me to believe was the reason. So we started today. Canadian Constitution Foundation, we went up today to start on our arguments on the merits. So a big part of, and I'll just summarize really briefly what we argued on the merits. So, because we only got through part of it. So much of the day was spent on this mootness application. So the crux of our argument in this case is that the government created this vaccine system where you needed to prove that you were vaccinated in order to enter all kinds of public spaces and private spaces like the homes of friends and family. So they created this system. They created these orders, and the orders did a whole bunch of different things. One of the things they did was create an application process. First, they had no exemptions. First, they had no medical exemptions. And we at the Canadian Constitution Foundation wrote to the government and we said, you need some type of exemption process. So 4 days after they got our letter, they created this really terrible exemption process system that kept changing. So the first thing to know about that exemption system is that for a period, you could only apply on an activity by activity basis. So every single time you wanted an exemption, every time you wanted to do something, if you were an unvaccinated person with an acceptable medical condition, you needed to apply to the government to be able to do that. So one of the people we're working with was a teenage girl. Her name was Erica, and she's the one who went and got her first dose of the COVID vaccine, like a good citizen was supposed to do. And she developed pericarditis, which is one of the most commonly recognized adverse side effects to COVID vaccines, especially in the younger population. So I think she was 17 when she got vaccinated and developed this heart inflammation. And the government created a mandatory form that in order to apply for an exemption, you needed to do a bunch of different steps. First, you needed a doctor to sign a letter for you that said that you had an adverse reaction or that you, for some medical reason, couldn't get vaccinated. But in order to write that letter, they needed to look at this other mandatory form that had 6 tick boxes, and you had to tick which condition you had. So the acceptable conditions were anaphylaxis, pericarditis or pericardial effusion. Both of these are types of heart inflammation. Another condition was a type of cancer treatment people were undergoing, so that made them ineligible to get vaccinated. So, and then they were different permutations of basically those three conditions. So Erica actually could have, she did have a doctor write a note, and she could have had her doctor tick that tick box. But the problem is she would need to apply every single time she wanted to do anything. So she could have applied to go to her swim class that she taught, except then she was fired for being a swim coach because she wasn't vaccinated, even though she wasn't vaccinated because she had a adverse reaction to the first dose. So if she'd been able to continue teaching at her swim club, she could have had an exemption to go to, a weekly activity. And they could have given her that exemption. But if she wanted to do something else, like go to the movies with her friends, go to her grandmother's birthday, which is something she wanted to do, go to see her boyfriend, she needed to apply every time she wanted to do that. And there wasn't going to be, you didn't know how long it would take. You basically, this teenage girl first needed to get her mom's permission to go about her life. And then she needed Bonnie Henry's permission, the public health officer here in British Columbia, to go about her daily life. And there was no guarantee that she would get it. On that form, she also needed to say why this activity was so important to her and why she couldn't do it remotely. This is completely bananas, completely outrageous. She was not treated the same way an unvaccinated person would have been treated. Like on Section 15, which is the charter right that guarantees our right to equality, you're entitled to equal treatment under the law. And Erica, this teenage girl, would not have been treated the same way a vaccinated person would have been treated. They didn't need to apply to the government every time they wanted to go about their life and do some basic socializing. But because Erica had a disability, she was being treated differently. That is discriminatory. And it's unjustified discrimination because the government could have just given her a blanket exemption. So that's sort of Erica's story. There was another woman in our case who I mentioned at the beginning of this video. Her name was Sharon. And Sharon had a different medical condition called brachial neuritis. So Sharon also went and got vaccinated, and then she developed an adverse reaction as well. Brachial neuritis paralyzes your arm and shoulder. So she was not able to move her arm. She needed to go and do physical therapy to try and regain movement of her arm. She subsequently got pregnant, which was wonderful news. She's now actually had the baby because this all has taken place over the course of a long period of time. The wheels of justice turn slowly. So Sharon had this brachial neuritis condition, and because it's related to nerve damage, she did not want to get pregnant. She did not want to get her second dose because she was pregnant, and she didn't want to run the risk that it could cause further nerve damage that could hurt her unborn baby. She was already worried enough that she was going to have her baby. She wasn't going to be able to hold her baby. And she had to see all of these different specialists, which if you live in Canada like me, you will know getting a referral to a specialist takes forever. But she did it. She saw a neurologist. She saw another type of doctor who helps with movement. I forget the name of the type of doctor. It's some other type of specialist. And she saw physiotherapists, and they told her her condition was an adverse reaction to the vaccine. They submitted a form for compensation to the federal government because of what they described as a vaccine injury. But she went to public health, and public health told her, your condition is temporary. It could resolve with therapy, and your condition is not life-threatening, even though it could have been life-threatening for her baby, her unborn baby. And they said, because of this, you should go and get your second dose. So Sharon didn't want to do that. She looked at the forms. She thought, maybe I can apply. But the form, as I said, it had these 6 tick boxes. And the only conditions that made you eligible to apply were if you had an anaphylactic allergy to a component of the vaccine, if you had a form of heart inflammation as an adverse reaction, or if you were undergoing some type of cancer treatment. Sharon's condition was just too uncommon, adverse reaction, to have been considered by the government. They didn't put it on that form. And her doctor didn't want to check one of these boxes because it didn't apply to her. Her doctor didn't want to send in a letter to public health because the College of Physicians in British Columbia sent a letter to all of the doctors in the province that said, if you submit an application for a vaccine exemption for a patient who isn't considered to have one of these acceptable conditions by the government, it could be a form of professional misconduct. So she couldn't get her doctor to send in the letter to public health because her doctor seemed to be afraid of the professional implications of straying outside of that tick box. And these were things that the lower court even found. So Sharon wasn't even able to apply for an exemption. This is a good faith person who really, she's not trying to, pull the wool over anyone's eyes. She's not trying to pull a trick. She really couldn't get vaccinated, and she was not able to apply because she didn't have a condition on that form, and her doctor was afraid to send in an application that didn't have a condition on that form. So then our third applicant is a woman named Veronica. As I said at the beginning, Veronica had a disability from birth. She had spina bifida, and as a result has impairments on her mobility. She has difficulty moving around. She needs mobility assistance. She also has, I don't know how many drug contraindications, but she's had adverse reactions to, a whole bunch of different medications. She's had 15 surgeries in her 30 years. And she didn't have an adverse reaction because she said, I am medically complex. My situation is really different. The vaccine hasn't been studied in people who have my condition. I don't feel safe getting it. I'm just not going to get vaccinated. And, she was like, maybe I'll just do less stuff. I already don't do that much, but maybe I'll just do less stuff. But the thing that she really needed is she needs therapy, like physical therapy for her mobility because of her disability. So she goes to the pool for 3 hours a day, which seems like a lot, but if that's the only time you're moving your body, it's not a whole lot. And she was not able to go to the pool because eventually, at first the government said, public pools you can still use. But then they changed the public health orders. They made them more restrictive, and Veronica was no longer able to use the pool. As a result of not being able to use the pool, her pain and disability got worse. She needed to increase the number of nerve blocking medications that she took. And she also gained weight, which made her, because she wasn't able to move her body. So that made her condition even worse. So Veronica, because she hadn't even had a first dose of the vaccine, she wasn't eligible to apply. Just like Sharon, there was no tick box that said, my situation is really unique and different. Please consider me anyway. And she also had the same concerns about getting a exemption letter from a doctor because she couldn't find a doctor willing to write one. As I said, the College of Physicians had sent this letter warning physicians not to write letters outside of that government-approved list of conditions for medical exemptions. So Veronica wasn't even eligible to apply. So we kind of briefly today in court went over highlighting these forms, walking the court through the forms. The court has been quite interventionist. They have asked a lot of questions as we have been making the arguments. Our lawyer, Jeffrey Trotter, has done a really outstanding job. He's an exceptional lawyer. If you ever need a lawyer in Vancouver, I really recommend him. But the court has been asking a lot of questions. I think on Erica's case, on the girl with pericarditis, I think that might be an angle that the court might be interested in because Erica is being treated so differently from a fully vaccinated people, even though she was able to apply. Even if she had successfully applied, she would have only been able to have an activity by activity exemption. So there's no way she could have been treated the same way as a vaccinated person unless she had the court resolve her case. So that's kind of what happened today. I'm really excited that the court is actually hearing the case because, as I said, so many of these cases have been dismissed on procedural grounds and they haven't ever even got to the merits. So we are really excited that over the next 2 days, we're going to be delving deep into the merits of this case and hearing the government defend this untenable position that I think that they're in. So if you subscribe to the channel, you will get an update when I'm coming live every day. I'm going to go live when we wrap up at court. We should be wrapping up around 4 o'clock Western time, Western Pacific time every day. So on Thursday and on Friday. And I don't know, people always ask me when I expect a decision. General rule, if there is a general rule, is it takes about 6 months to get a decision. It could be shorter, it could be longer. We never really know. This case also involves another organization, so that may add to the time constraint, but we never know. So you can also follow me on Twitter. My Twitter handle is @CVanGeyn. That's CVANGEYN. And I will be live tweeting what is happening in court. So you can see what is happening if you want to read along. Some of it is pretty technical. I've tried to not delve too deeply into some of the technical parts of the case in this live update. A lot of what is happening in court has to do with the standard of review, which is like a little difficult for even lawyers are not that interested in standard of review. I think a few of them are, but it's something that it's hard to explain to the general public because it's difficult concepts. Basically, the standard of review is whether the decision was reasonable or whether the decision is correct and which standard applies. We want correctness to apply, and we think that the decision maker is the lower court judge, so he doesn't get deference. And we think that the part of what we're going to be discussing in court is who interpreted these forms and how these different forms should be interpreted. And it depends on who did the interpretation, whether or not it was the lower court judge or whether or not it was the public health officer Bonnie Henry who interpreted the forms. And we think it was the lower court judge is the only legal interpretation we've actually seen of these forms. Because what the government has argued in this case, the way they're, phrasing their argument is that they, we had these mandatory forms with the 6 tick boxes and the requirement to send a letter from your physician. But what the government has said is that they actually were secretly not even following their own requirements that they imposed on the public. They secretly granted exemptions to people who were outside of those 6 tick boxes, but they didn't tell anyone that they were doing that, and that our applicants should have known that the government was secretly not following its own law and they should have applied anyway. And, from an administrative law perspective, that's an untenable position. You can't remedy an unconstitutional law or order by saying, well, we didn't actually follow our own law. Like that absolutely cannot stand. So that's a big part of what we are going to be addressing in the coming days. So I hope that you will follow on Twitter. And if you want to learn more about the cases of these women, I actually explore it pretty in depth in my new book that is just about to come out. It's available on Amazon. It's called Pandemic Panic. This is a flyer for the book, by the way. I don't have a physical copy with me. But the book explores the cases of these women, and it explores the cases of all kinds of different rights that were impacted throughout the pandemic. So freedom of religion, freedom of expression, freedom of assembly. I talk about the convoy and the use of the Emergencies Act. We talk about democracy and the rule of law, about our privacy rights. So I hope you consider reading it. You can if you search it on Amazon, if you search Pandemic Panic, you'll be able to find it there. And we talk about this case in the book, although the book is not going to include what happened today because it's already headed to print. So thanks for tuning in. And I hope that you will tune in the next few days as well, where I will have more to say on the merits of the case. We only just started today, but the big news today is that the court decided to hear the case. The government failed in their attempt to have us kicked out of court. They failed on their move to claim that this was a moot case that shouldn't be heard and procedurally block us from seeking justice for these women involved in the case. So I'm happy about that. That is a great outcome today. And I hope you tune in tomorrow. Okay, bye everyone.